I think we're gonna go ahead and get started. All right, guys, thanks for joining us this evening to discuss a very exciting topic, marijuana in the workplace. And we even have gummy party favors, and no, they do not have weed in them. I'm Maddie Maruna. I'm an employment attorney at Cabbage, and I'm also joined by my Cabbage colleagues and fellow employment attorneys, Doug DePalma and Max Stain. Cabbage has been around as a law firm for over 100 years, advising primarily closely held businesses in Northeast Ohio. And aside from litigation, which Doug, Max, and I do pretty regularly, it's our job to make sure that our clients stay out of court. And since Ohioans voted to legalize marijuana as recreational, we've been getting a lot of questions from employers on how to deal with marijuana in their workplace. Does anything change now that we're not just a medical marijuana state? So we gathered a group of industry experts who were kind enough to grace us with their presence here this evening, and also some of our employer clients who are on the front lines of employment to have an open discussion about the issue today. Hopefully you walk away with a little more knowledge than you came into this meeting with. So I'll just briefly introduce the rest of our panelists who are not Cabbage attorneys. I have Ed Bamlin here with us today. He is a drug recognition expert at Olmsted Township Police Department. We also have Stacy Stefanik. She's a partner at Stefanik, Lowe's and Associates, focusing on Ohio workers' compensation law. And we also have with us one of our clients, Bo Hill. He's the executive director at the Salvation Army's Harbor Lake Complex here in Cleveland, Ohio. And last but not least, Craig Kwasniewski. He's the director of human resources at Discount Drug Mart. So to kick things off, I'll just pose a general question to Max and Doug, and they can get us started. Can both of you just briefly describe the issues that our clients are facing regarding marijuana in the workplace and the questions that we've been receiving?
Go ahead, Max.
I think that the issue is, it's pretty well known. I mean, most workplaces had a drug-free workplace policy, and that included marijuana. If you test positive for marijuana, we won't hire you. If you test positive for marijuana during the pendency of your employment, we may let you go. And then obviously there are the instances of workplace accidents, et cetera, which Stacy knows a lot more about than I do. A couple of things have come together to change that. First of all, again, a lot of folks know better than I do, there's a lot of difficulty in staffing a lot of workplaces. And we're at a point where you've got tough choices to make in terms of enforcing that kind of a rule with respect to marijuana particularly. And second is that marijuana is about to be legal in Ohio. And you gotta ask yourself, do I really want to press the issue? There's a lot of other questions beyond that. Are you doing federal work? Are there any other reasons that you wouldn't allow folks to test positive for marijuana? We'll get into a lot of that, but that's kind of crudely how the issue frames up as we're sitting here, I think.
I would only add that one of the things that the passage of the recreational marijuana law, it caused a lot of the clients I deal with to focus on the problem. We addressed it when medical marijuana was first passed with a number of our clients, and we created policies for them to address that situation. Then the question started to arise: what's different? Do we need to modify our policy, or what do we do in this particular instance? And then we start, developing approaches, and it depends on your workforce and what kind of business you're in. As Max said or alluded to, under federal law, the recreational marijuana is illegal federally. It's still a controlled substance under the Controlled Substances Control Act, and it also violates the Federal Drug-Free Workplace Act. So employers have a wide range of approaches that they can take. They can be very strict, or they can be liberal. And then what does that mean? On the strict side, it means if anyone tests positive either on a pre-employment drug test or after they're hired, you can fire them. They're not protected. On the other hand, that has a could have a big impact on your employment, on your workforce. You know, studies have shown that 73% of employees value corporate culture more important than salary. And they might feel that what they do on their free time, so long as it doesn't impact the workforce, is their business. And that might impact how many employees you can hire and retain. One employer in particular had a workers' comp issue. An employee cut her fingers off in a lumberyard. And we talked about enforcing the Drug-Free Workplace Act, and my employer said, if I enforce that act, I have to fire 50% of my people. So it creates each employer, depending on who your workforce is, what your culture is, what your expectations are, what theirs are, you're going to have to modify your policies to maximize your hiring and retention while maintaining your own corporate culture. So it's worth the discussion, and those are the kinds of things that have been coming up. But mostly, the new laws caused our employers to focus again on the problem.
So I think it's a little bit of a balancing act, right? And we're here tonight to help you kind of work through that. So, Bo, I'm really interested to hear how the Salvation Army is handling this issue. I think they're placed kind of uniquely in that they are an employer, but they also run addiction recovery services. So, how are you guys handling marijuana, alcohol, substances in the workplace currently?
So it's a very challenging question, Maddie. And the Salvation Army is actually incorporated in New York, and so we fall under all of their bylaws and all their rules and policies, and they're still really evaluating it. So we are making sure that we're doing the right thing we can locally. And so we kind of have two approaches. There's the approach to our employees, and then there's also an approach to the people that we are called to serve. And in both cases, we have to show grace. All right? For those that we serve, the level of grace that we're able to show depends upon the program that they're in. And so for those that come to us that are homeless, we obviously want to work with them so that they get into a permanent placement, and we may show more grace to them than someone that comes to us that needs detox or something like that. And so it's a very much so a balancing act right now, and we're trying to navigate that the best way we can.
And I think actually a lot of the Salvation Army's employees are former clients. Is that fair?
That is very much the case, and actually have a former coworker here in the audience as well that can attest to that we hire a lot of people that have come through our programs. And so when you're talking about people in recovery, and you talk about them being around marijuana or something like that, people say that the slippery slope doesn't exist and things like that. In my experience, after 28 years, it does.
Fair enough. Craig, I'm interested in Discount Drug Mart's perspective here too. I mean, you guys run a very large operation here in Ohio. How have you maintained staffing levels while still, protecting your workplace with regard to marijuana usage and other drug usage?
It's changed, Maddie, over the years. I mean, just a few years ago, we were drug testing for every single position, whether you're a stock employee or working at the corporate office. That has rapidly changed. Where now we are not, for example, there are certain positions that we are not testing for just because of necessity.
So what I'm hearing is you don't think that you could probably maintain a full workforce if you were testing for, all of these different positions at this point.
Correct.
Right. So Ed, I want to move to you. I know that a lot of people here tonight are interested to hear you speak. Ed is a drug recognition expert, so he has a lot of knowledge to share with you guys this evening. So I know that there is no current objective test right now for marijuana like there is for a breathalyzer for alcohol. So how do you and your fellow officers determine whether somebody is high, like during a field sobriety test?
So the standardized field sobriety tests, which are the 3 tests that the officers give on the side of the road, they're not pass or fail in totality of the circumstances. It's how the person performs during those tests and also what the officer sees, hears, and smells. So what the person is saying, how they're saying it, how they appear, and if they smell the odor of alcohol or marijuana coming off of the person. On top of that, there are officers who are trained slightly beyond that to an advanced stage of field sobriety tests. And then there's the drug recognition experts. The drug recognition experts, we utilize a 12-step program to interview and physically test the person. It takes about an hour, and through that process, we can accurately determine which one of the 7 drug categories that the person is impaired by. That is then backed up through a urine toxicology test. And Ohio is looking at oral fluids, a oral fluid swab, which would need to be sent out to a lab, but it's just as accurate as a urine test for illicit drugs.
Can I ask you a question?
Oh, yeah, absolutely.
I had a special request from an employer to ask you. So Ed's a drug recognition expert. That's a credential
Yes.
that you hold. And his question is, and he operates a manufacturing facility. His question was, if I can't reach a guy like Ed, and I know there's several hundred drug recognition experts in Ohio, but let's just say that's tough for me. Is there kind of a layperson's test that we can train up on so that a supervisor or an HR person or whoever can maybe conduct a test that we can depend upon as reasonably giving rise to suspicion of marijuana intoxication?
So, yes, you don't have to go through all of the training that I've been through to look at somebody and notice their impairment or notice that they don't appear to be acting correctly. You can use your senses. Everybody who's seen somebody who's drunk, you didn't have to go through a training class to know what somebody who's drunk feels like. So if you've seen somebody who may have been under the influence of another substance and have an idea of what that looks like, you can start utilizing your senses, your experiences to document those things and start going down the road of an impairment.
Is that something that you can impart to folks? I mean, could they learn that from you, or how would they acquire those skills?
There are certain checklists that.
We can't hear what he's saying, like really important information.
Here,
Oh,
that's the
I-
mic. That's the mic.
My mic.
Oh, yeah, I'm sorry.
All right, can you hear me now? All right, so there are different things that you can look at. You can look at the person's eyes, if their eyes are red or look pink, like they have pink eye. If they have the odor of marijuana coming off of them, they appear to be paranoid, they have altered perception of time and distance. Those are all things that officers on the road who are trained in the detection of a drug impaired driver start to look for when they're looking at somebody who's potentially impaired behind the wheel, and not just by alcohol.
And just kind of building off of that, is there any services that you know of that will certify somebody who's not a police officer as a drug recognition expert? Like if somebody wanted to send, their HR person to receive specific training, do you have any knowledge of that?
Not to my knowledge right now, because the drug recognition expert category and certification is through the National Highway Traffic Safety Administration, so it's typically through the public sector that gets done. But there are some attorneys who have been through the program, such as the traffic resource prosecutors, that can possibly give you guys some information that you're looking for.
Sure, Doug, do you have something to
No,
say?
actually, I want to put it in context a little bit. What Ed is talking about, the usefulness of a drug recognition expert, that has relevance if you're a tolerant employer. If you're an intolerant, if you don't want to have, if you want to maintain a drug-free workplace, any employee who tests positive before or after you can fire, and it doesn't matter when they used it. But if you fit into the category, I think of most employers are going to be, which is more on the tolerant side, whether or not they've used marijuana isn't the issue, because someone can use marijuana and still test positive a week or 2 weeks later. The issue for those employers is it's not whether or not you've used marijuana, it's are you impaired on my workforce, right? And impairment is something we don't have a test for. If you test, you can take a breathalyzer test, and as a matter of law, you're impaired to drive. But if you have someone in your workforce and you don't want to fire him just because he used marijuana, it's not your policy, but you want to fire him just as if he were an alcoholic. If he had been drinking alcohol and was a danger to the workforce or was impacting his productivity, you wouldn't tolerate that, right? So your position is more likely going to be, it's not that you're using marijuana, it's are you impaired while you're at my workplace? And that's where someone like Ed comes in. And you know, they said there's all sorts of tests that can be used in addition to smell and eyes, eye dilation. But then you're into the world of, are you impaired? The employee's going to say no, you're going to say you are, and then you're going to make a decision on whether or not you're going to fire them, send them to drug rehab, who knows. But let's say you decide, I'm going to fire this employee because I think they're impaired. And let's just say, for the sake of argument, that employee fits into a protected category. They're over 40, they're African American, they're a woman, right? They fit into some, and when you fire them for what you believe to be impairment, right? If they think they've been unfairly treated, they're going to bring a lawsuit. And they're going to claim, I was fired not because I was impaired. I was fired because I fit into one of these protected categories. Now you're going to have to come up with some evidence that that employee was in fact impaired. Does it have to be the kind of evidence that it needs in a criminal case? No, but it's got to be reasonable, right? You just can't say, in fact, I think even saying I smell marijuana wouldn't be enough because they could linger on their clothes.
That's fair.
So that's where someone like Ed becomes important, and why an HR person who has some training and maybe a checklist of things that they check so it looks your decision of impairment that you use to base your employment decision appears reasonable. And if you do that, you win your case.
Can
You
you
don't-
underline that word reasonable? That's really kind of
Well,
the
that's what
operative
it-
term.
Yeah. well,
Let's talk to Stacy a little bit about what might be reasonable from a workers' compensation defense perspective. I know that that's on a lot of employers' minds right now. You know, somebody's injured at work. What happens if they're impaired? So, Stacy, can you just discuss briefly what are the types of policies that employers should have in place to put them in the best position when the Bureau is investigating a workplace injury?
Well, number one would be the drug test, because under the statute for alcohol, you have to have this drug test within 8 hours, and for chemical is 32 hours. So there's a very short window where if you're an employer and someone's injured at work, the time is going to pass you by before you know it. And then you're going to call me and say, I think they were intoxicated, and I'm going to say, do you have a drug test? And if you say no, that's not a defense that I can argue. I need the actual test. So reporting and post-accident drug tests are the most important to me if an employer wants to defend an injury and state it was because of drug use. If there's no test there, I legally have no basis to argue that at an industrial commission hearing.
So in addition to the test, would it be helpful for you from a defense perspective to have real-time accounts of how the injury actually occurred, as well as maybe, you know, an attestation by the HR professional as to, you know, did their eyes appear red? Did they smell marijuana? Were they able to accurately, you know, say what day and time it was? Would that be useful for you?
Not for me.
Okay.
The most useful is the test. We don't have witnesses saying he was acting a little weird. To me, I need the actual test. So I would like an employee statement to see what they think happened. I would like a supervisor statement. And then a good setup for an employer is to have the policy that if you're injured, you go seek medical attention immediately. Because if you send your employee to someone who does occupational injuries, usually they're going to be drug testing as just a matter of a visit. And if an employee chooses to go to the ER or their own personal doctor, usually the ER or their personal doctor isn't going to do a drug test. But if you have a company and you set up, this is the location of the urgent care we want you to go to, usually you're choosing someone who does work injuries, and as a matter of course, they're going to do the drug test immediately.
Okay. Max, Haze and Doug, I'm gonna kind of kick the question to you now. So I know that we've heard a lot about how there could be potential discrimination issues here. You know, you say that you're terminating somebody because they are impaired and there was an injury or something of that nature, but they say, whoa, 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 actually it's because I'm a woman or some other protected class. Do you guys think that those policies that Ed was talking about, if they had some real-time accounting of the incident that occurred, as well as, you know, potential objective criteria that the HR person is checking off, would that be useful for us as we're litigating a case?
As we advise employers, and I hope I'm not missing the point, but policies make a tremendous amount of sense. To have policies in place that says upon an accident you will test, to have policies in place that I can randomly test. Those have to be, or at least it's very helpful, if those are agreed and it's understood that if you decline to test, we're going to separate. I don't know, Manny, if that speaks to your question.
Yeah, I think just kind of from a litigation perspective, if you did have a real-time account of an injury that took place or an incident that took place in the workplace, and you had your HR person say, hey, you know, I talked to this person, their eyes were glassy, I smelled marijuana, and, you know, kind of lay out everything they looked at in making that termination decision, that's going to be very helpful. Doug, do you want to comment as well?
In focusing on the issue of the particular problem of marijuana, because as I said, you can test for it. Someone can smoke marijuana or whatever extracts they take. That can remain in their system for a long period of time. So it's not the chemical testing that's relevant. The employee may even admit, yeah, I smoked it 5 days ago. That would be perfectly correct. The issue is, are you impaired? And if you're a more tolerant employer and you want to discharge or have a job action for someone in your employment, you have to show impairment in some way. And I think that having a checklist of 10 or 15 items that someone goes through, almost like a roadside test. Can you stand on one foot? Are your eyes dilated? Is there an odor of alcohol? Is as you suggested, can you repeat a sentence, or what's the date and time? There's a whole series of tests that you can ask, and your observations as the HR person or the shop person on the floor, you check them off. That becomes evidence, right? And does it have to be 100% right? No. It just has to be reasonable. And as Max pointed out, well, what's reasonable? Well, a judge and jury might figure out what's reasonable, but at least you've got an argument. You've got a basis to say, this is what I based my conclusion on. This is what I observed. This is what we found. To me, that was enough. And that gets you in the court. And I think if you have the right checklist, I think you're going to win.
And Stacey, just from a workers' comp perspective, if somebody tests positive for marijuana, you said those objective tests are very important for your defense. If somebody tests positive, what impact does that have on the Bureau allowing the claim or disallowing the claim?
Well, let me maybe explain the levels of the workers' compensation system. When someone initially files a claim, they are working with the Bureau of Workers' Compensation. So the Bureau of Workers' Compensation may not have a positive drug test on file when they're making the initial decision. That's why, as an employer, it's very important that you are participating in your defense right when the claim is filed. Because the Bureau may make a determination without all evidence on file, and if you don't have the positive drug test on file, or say, hey, we as the employer are contesting this because we know there was a positive drug test, the Bureau could just approve their claim because they don't know it exists. And if the employer doesn't appeal that decision, then that decision stands. But if you're an active employer and you're defending or investigating your claims, you can file that evidence with the Bureau of Workers' Compensation and appeal their decision, and that ends up in a workers' compensation hearing where you can argue, here's the drug test. We usually get a doctor report as well, because you have to show the drug was the cause of the accident, not something else. At that point, the burden shifts to the worker to show the drug was not the cause of the accident. So the answer to that is, I think it's very important from the beginning that you're submitting your defense if you think that the accident was the cause of the drug.
But Stacy, just to reiterate, you had said earlier, and I know it's true, is that you're not really interested in Ed's evidence that he's going to generate. As you're sitting in that hearing room and you're talking about what's the cause of this workplace accident, just having tested positive for marijuana isn't very convincing. You're going to have an employee who's going to sit there and tell the officer, it was 5 days ago. It had nothing to do with the accident. To reiterate, there's no value in determining whether an expert could have found them intoxicated at the time of the accident.
Besides a medical expert?
Yeah.
Without a test?
Right. Well, let's say both. Let's say you've got a blood test that says they're positive for marijuana. And is there any value in some objective test that says, or subjective test, whichever, that says they also appeared, they gave evidence of being intoxicated?
Well, from an employer standpoint, that is, if there's a reasonable suspicion that you think they're intoxicated, you can have them take the drug test.
Yeah.
So from that perspective, it's important because the employer is flagging, I think the cause of this was because they were intoxicated, and they actually take initial steps.
Okay.
But if I go down to an industrial commission hearing and I don't have a positive drug test, I can't argue that.
Fair enough. So maybe you want both. So if Ed is trained, your HR person.
I would love Ed to be my HR person.
Exactly. And you get the blood test. So what you're saying is don't depend on Ed or Ed's testing.
Definitely.
But Ed's testing could be useful in combination with the blood test. Is that fair?
It's a flag.
Yeah.
We think this situation is not right.
Right.
And that involves investigating further.
Okay.
Yeah, well,
So I have some peers that run other social service agencies that are going to take a more liberal approach to marijuana than I think we are as the Salvation Army. And the challenge that we have when we're operating 24/7 facilities is oftentimes the skill set associated with those people that work at 3 a.m. on a Sunday morning are very different than those that work 9 to 5. And you're nodding, so I'm assuming that it's a similar case with you. So when we're talking about reasonableness, that didn't cause an accident or something like that, but it's an impairment, very evident impairment, and that person that's doing that isn't necessarily a trained professional, but it's something that as an employer, you have to address at that time. That gets down a road that is very, very difficult, I think, in our worlds. And did I say that somewhat right in your space as well? So that to me is a huge issue in the social service sphere. And I don't think they know how to deal with that.
so I think that we have definitely some HR professionals in the crowd. So Craig, I want to direct this question to you. Discount Drug Mart is a huge organization. How do you, as an HR director, stay organized when there is a potential impairment issue? Do you direct the supervisors to handle that, and when do you step in as the HR director?
Well, it's gotten to the point, Maddie, where we actually have someone that this is their job. Not only drug testing, but they are the liaison for risk management. So that's our investment.
So do you guys have a kind of step-by-step process that you utilize, like Ed discussed, or what does that look like for Discount Drug Mart?
We do. It's not an exact checklist that we're going off of, but many of the things that Ed mentioned, we do look for.
Okay. And Bo, how do you guys handle that right now? Does that come to you as the executive director?
We have an HR person, but we get a lot of calls in the middle of the night, and it's a real challenge because that impairment may not elicit an accident or something like that, but it is critical to the care of those that we are called to serve. And sometimes that individual that's our staff person doesn't see that, and it's difficult.
So Ed, another question for you. I know that you said that, really just police officers and there's a few attorneys that you know that are the drug recognition experts. Are there any other, services that you can recommend to the folks in the audience that can kind of perform a similar type analysis that might be able to be utilized in a civil litigation context? And it's okay if the answer is no.
I'm sorry, I'm processing it. So, not to my knowledge,
Okay.
but if you suspect somebody is at your place of business and they're impaired, whether it by drugs or alcohol, even if they haven't caused the problem or have been injured, you can approach them and with your suspicion, or you can contact your local police department. Your local police department can go and be the bad guy. That's what we get paid for. We can go be the bad guy, go talk to that person. And if we feel that they are impaired or that there is another issue going on, we can either A, escort them off of your property because you don't want them there, or B, we can call an ambulance and have them taken to a hospital for an evaluation medically to see if there's an underlying cause that maybe we weren't thinking about.
So you would actually be able to go to an employer's place of business if, an employee is causing an issue and perform the same drug recognition test that you would do, let's say like on, a road for a field sobriety test.
Absolutely, I've done it for employers in our township.
That's interesting, I didn't know that.
Yes,
Do you ever have anybody say, no, I'm not participating?
absolutely. And it falls under the same as refusing to do my tests if you're driving.
Can I add something?
Oh, yeah, absolutely,
No,
sure.
no, please.
I just want to say, if you don't have a drug test, don't let that claim go by. I can still contest these claims on many other reasons. Okay? I'm just saying the best reason is if you have the test.
Doug, did you have something
What I
else
was
to
going to
comment?
suggest is for the employers I counsel, I would not ask the police to come to the workplace. I think that would be too intimidating to the staff. What I would do, or what I would recommend, is we have it now. We have our own list of 20 different things that can be checked. Some of them are harder than others. You don't need 20, but we could come up with a list of 8 or 9 things that an HR person can do with a checklist. And I think that's good evidence. It doesn't have to be right, it just has to be reasonable. So if you have a protocol and you're looking at eye dilation with a flashlight and they're doing the one leg test and they're touching their nose or half a dozen things like that, that's what I would use rather than calling it a police.
Are you filming that test?
Huh?
Are you filming that test?
You could.
Since you asked that question, Doug is our main person that we call for everything. And thank God for Doug. We have cameras everywhere. And so pretty much any time that there's an issue that comes up, he wants us to save a copy of the video.
Yes, my general rule with him, because their buildings have so many cameras, I tell them internally, if you ever have to look at a video, I want it. Don't delete it, keep it. Because it's oftentimes the very, very best evidence, right?
And it's very difficult because we only have limited space and limited capacity, and our facilities are large, and it takes a lot of expense to keep and track all that video.
It saved us more than once.
That's correct.
So I want to transition a little bit, and I'll pose this question to Max and Doug. We've been talking a lot about kind of like the day-to-day employment grind and also workers' compensation law. But another statute that's implicated with marijuana usage is the Americans with Disabilities Act and then the Ohio state law equivalent. Max and Doug, can you guys comment on how those statutes come into place and how employers should deal with the issue?
Well, excuse me. To begin with, at least from my perspective, first of all, the matter that passed here in Ohio in November explicitly carved out any kind of cause of action that would say, I get to use marijuana because. There is, to my knowledge, the Americans with Disabilities Act, neither the Americans with Disabilities Act nor what Ohio's just done really affects that. But Doug pointed out earlier today when we were having this conversation that addiction may be a disability.
There's a teeny weeny space where the federal law might protect someone who is an abuser of marijuana / addicted. There is a designation called an abuser. If that person is about to be disciplined and that person then claims to be an addict and is going to seek services like addiction services, there is a very strong argument that they are now disabled under the Americans with Disabilities Act, and that the request that they be allowed to take time off work to receive counseling would be a reasonable accommodation under the ADA, with the condition that they remain, that they don't use marijuana at all. Because under the federal act, you can't be an ongoing user. But that's a very, very teeny space, and it's very nuanced. But for most employers, I think what you need to know is that the federal laws, the Americans with Disabilities Act, 99.9% of the time has no application. There's this one little area, but it's nuancing.
And I didn't mean to interrupt you, but application or no application, nothing gets you off the hook for being high at work.
That's true.
You know, we don't care if you're an alcoholic. If you need treatment, get treatment. Don't come to work drunk. And that's the same with any psychiatric, psychological, or other personality difficulty that you may be experiencing. We will still, our employers will still
Actually, let me give you an
enforce
example.
their norms.
Let me give you an example to illustrate that point. An employee is late for work. The manager confronts him, and the employee says, you know, I was drunk last night and I was hungover this morning, so I came in late. But I realize I have a problem, and I'm going to go to Alcoholics Anonymous. Right? As soon as that employee says that he's not going to use it anymore and he's going to alcoholic, he's protected. But he still gets disciplined for showing up late. And on an ongoing basis, he can't show up at work. He doesn't get protected. Again, you have to stop using in order to get the protections of the ADA. But this sort of illustrates, you can discipline him for being late, you can discipline him for drinking, but once he claims he's seeking recovery, he's protected under the ADA.
So we did want to leave some time for questions. I mean, you guys have 6, really intelligent folks up here that are industry experts, legal experts. Feel free to ask your questions. I think, Alyssa, do you have another microphone? Oh, well, I will pass around my microphone to anybody that has questions. Any takers? Oh, Hal, I'll be right back to you.
What are the rights to search, like the work area or the workplace or the locker or the office?
Search them away, search away.
No detectors.
Yeah, in fact, in our, at least for me, the employee manuals that I draft or involved in, we specifically write in the employee manual, this is our property, we own everything, we have the right to search everything, and we do. The only thing we don't search is their cars in the parking lot.
Yeah, but you can, if it's your parking lot. You should have a policy in your handbook that says, do not expect privacy on my property.
Yeah.
And that would include cars. And if I think you stole something, I know that's not the topic for today, but I have the right to search your car. And if I have reason to believe that there's narcotics, whatever. So you do not, from my perspective,
Yeah.
generally. But it's good to have a policy that makes that
That's what we do,
explicit.
even briefcases. We make a long list of things so there's no misunderstanding.
And there is a sphere of privacy into which an employer can't poke into. But generally, what happens on the employer's property is not subject to that, and having a policy in place makes that clear.
And when we draft employee handbooks, it's pretty fair to say we try and make that sphere as small as possible.
Well, you don't want to be, big brother either.
Fair.
So That's why I might give them the cars, but, you know, it's up to the employer.
I don't think I'd give them the cars.
Can you, they can't quite hear in the back, can they turn up the sound a little bit?
Yeah, sure.
All right, thank you.
Okay, I think we have another question over here.
Yes, so I was just curious, in terms of workers' compensation, there was a lot of talk about needing a drug test, a positive drug test specifically. Are you guys able to, and how would you argue a refusal to take a drug test from an employee who's suspected under reasonable suspicion?
Well, that becomes more difficult with employers now because of the difficulty of finding a workforce.
Right.
I would terminate this employee, but some employers are finding it hard to find employees. And so that's really your call as the employer if you want to lose an employee. I don't know in the past year how often that has come up to you. I don't think it's over and over again. It may be a couple times a year you encounter that, so it may be worth it to you as an employer.
Right.
Especially different industries too. If you're in a construction company or a trucking company, I think you take a harder look at termination than if you're at a retail store where you're not going to injure other employees maybe.
Right.
So it also depends on industry. I would terminate that person immediately. That's why it's important to have a handbook. If you refuse to take this test, it's instant termination, and that's the importance of a handbook. But as an employer, it's your call. I would treat each employee uniformly and not say, I don't like this person, they're refusing, I'm going to terminate them, but this person over here refused and I'm not terminating them. So I would terminate, but I think each employer evaluates that differently.
We've actually had people that are in recovery that work for us, and our role has been, if you come to us and you need help, we're going to help you. If we go to you, then unfortunately no. And there's been, I've very dear friends that I've suspected, and when we ask them, they say, "Oh no, Bo, we can't do this." And good luck, God bless you, I love you, but you're no longer working with us.
Do we have any other questions?
I have a situation that happened. We had a supervisor, team leader on second shift who was acting very erratically. The people that worked for him called the operations manager, showed up at 11 o'clock, and said, you know, we got to take you for a drug test. He said, sure, which of course shocked us. We figured he'd be like, no, thank you, I'm leaving. He went and he came back clean. And he said, it's weird. Okay. And so then the next week he acted way more erratically, falling down onto pallets of boxes, just practically falling asleep. And at that point, we just terminated, like, you know, you just can't be here any longer. And some of the employees who know more about recreational drugs than I do said that there are some synthetics that will not show up on a drug test. And you're nodding your head.
That is absolutely correct. A drug recognition expert, if that synthetic drug falls under one of the 7 different drug categories, we will call the drug category that it falls into. We will not call the specific drug. And that's even with naturally occurring drugs. We will let the toxicology test tell us what the specific drug
It came back negative.
Correct. There are only a few labs in the country that will test for these new designer and synthetic drugs. One of them is, I believe it's NMI out of Minnesota. But you have to tell them what you suspect and are looking for.
Okay.
And if you can't get that out of your employee or out of the person that you're talking to, good luck. Because the way that it's written in the Ohio state law, synthetics are illegal. And up until a few years ago, all they had to do was just change one chemical, and that composition then became legal again. But Ohio covered that base with a criminal simulation.
Anybody else? Over here.
I have a question. So say someone gets arrested, off duty, or they get an OPI for marijuana use. you have any recommendations in those cases?
So if they are a commercial driver, or if they carry any sort of a driving requirement, they're put out of service. If they're arrested for an OVI, they're put out of service per a piece of paper that they're given through the BMV for, I believe it's 72 hours. And then it's up to you guys what you do from there.
Max and Doug, do you want to comment, and Stacy as well, kind of from like a negligent retention standpoint, the potential liability that could exist there?
I would say first, if you choose to terminate that person for that reason, I don't see any basis for you to suffer any liability as a result. We're a right to work, in Ohio, as in most states, you can terminate for any lawful reason. That's not an unlawful reason. As far as negligent retention, if it's off duty, I don't know if that comes to play, at least in my mind, unless you have reason to believe that this individual is addicted or otherwise likely to cause harm in the workplace.
Yeah, I would agree. But one thing you would want to consider, particularly if that employee is a driver for your company, how that may impact your insurance coverage.
Do you have any other questions, guys?
So is there any liability or risk if you're applying one policy for drug testing to one group of employees, say office folks, and then a second policy to folks that are in the shop? What's your advice on something like that?
I think you could.
I was looking at Stacy.
Oh,
I
this
think
is
you
you
can.
too.
Yeah, I think you can.
Absolutely. I mean, commonsensically, if you're running a lathe, I've got different concerns than if you're answering phones. And so I think that there's nothing wrong with that. But it's easy to stub your toe on allegations of unfair and discriminatory treatment. So if it's, if one position is, by example, we can almost segregate it by sex. Then, you may be flirting with allegations that, gee whiz, it seems like you're more interested in women who are intoxicated, or more harsh with your response. But generally, I think common sense can govern the workplace, and if it makes more difference for one individual in that job than it does for another individual in that job, I think that's fair.
Actually, well, and I would add that it's not uncommon to have two employee manuals, one for an executive workforce and one for a different designate. It could be floor people or whatever. But we've done that oftentimes because there are different requirements, different expectations. One of them might be drug use. Yeah, so I think you can, and depending on what a bright line you have, you may want to consider having two separate manuals.
And Craig, I think you actually said that Discount Drug Mart does have this policy now, so you're kind of segregating based on position when you're drug testing.
Yes,
Is that
that's
accurate?
correct, yes.
Okay. Any other questions? Yeah.
Just out of curiosity, which groups are you drug testing for and not? Because we're running into that problem as well. We knew the city of Cleveland was going to adopt that, but they haven't fully rolled theirs out either. And I'm curious to see which groups you are testing for.
Yep, so that's a great question. And we're testing for office positions, and for in the stores is where we really have backed it off. So we're not doing stock employees, cashiers, things like that. We're not doing.
What about your pharmacists?
Pharmacists we do, yes.
Any other questions?
So I'm just curious about if there is an incident and somebody tests positive and we didn't have any suspicion, or maybe we did. I mean, litigiously, how much is the company liable? So someone's driving a fleet vehicle, or they're driving a tow motor, and there is an incident. I mean, were we supposed to have known or suspected? So, I mean, at some point, when does that become something that the organization is responsible for and not just the individual?
Sorry, so I think, Max and Doug, you can comment as well, but I think that kind of goes to what I was talking about with negligent retention, negligent hiring. So where you become liable as an employer is when you know that there is a problem with an employee, you don't deal with that problem and retain that employee, and then the same problem happens again. So let's say that you have an employee who injures somebody else because they come to work drunk. You know they were drunk, maybe they're disciplined, but you still retain that employee and allow them to keep working.
Or you don't know, like either way, at what point is that the fault of, or is it how much it is on the organization side?
So you have to prove knowledge. You have to prove that you guys had knowledge. Max and Doug, do you have any other?
Absolutely. You can't be liable for something you didn't know about. You can't act. But if you do have knowledge, depending on the degree of that knowledge, then your risk of being liable for negligent retention is going to go up. You know, and slightly off topic. You know, there are also, for example, policies about distracted driving. You know, there have been many cases where employers have failed to have policies that make it clear that their employees should not be talking on the phone while driving a company vehicle. And then, one famous case, a lawyer in DC killed a jogger. The law firm was sued for $32 million. That was the judgment. You know, so sometimes, anticipating a problem, it'd be nice to have a policy that says you can't do this, and then if they go ahead and do it, you at least have an argument that they were acting outside the scope of their authority. But that's good science.
This will be kind of a cynical response, but if the lawyer's looking to sue somebody, the employer is going to be a lot more attractive with a lot deeper pockets than the fellow that, you know, crossed the center line and hurt somebody. So I think the more precautions, probably the better.
And then, of course, your general liability insurance should apply. So,
Do we have any other questions? Alyssa, did you say there's one over here? No? Oh, yeah.
My business is actually regulated federally with the SEC. So would I even have the option of having a lenient policy, or is it because, you know, weapon laws are really state driven? Would that be the law that I would look at?
You may be stuck with the zero tolerance. And Bo has that same issue because at the Salvation Army, they receive a lot of federal grants, and they don't have that leeway in those programs that are funded by federal money.
Great. I don't think I'm seeing any other questions right now. So there'll be food and drinks, and we're so happy that you guys are here to join us. Can we give the panelists a round of applause? Thanks, everybody. Don't forget to drink, eat, and mingle.
Thanks a lot.
Perfect. So, Doug, now that we have recreational marijuana in Ohio, what is the first thing an employer should consider in managing their workforce?
Well, obviously the legality of the marijuana is not really relevant anymore. Given the situation, an employer has to decide as an initial matter whether they're going to be more or less tolerant. If they're going to be more tolerant, then all sorts of issues about new policies should be considered. What constitutes impairment, how they're going to determine impairment become relevant. If you're going to be less tolerant, then it's kind of easy. You can take whatever job action you want against anyone who tests positive or even that you suspect of drug use.
So if an employer wants to become a little bit more tolerant, what are some employee policies in their handbook that should probably be revisited?
First thing, it should be made clear that employees, recreational marijuana or not, they can't be impaired while they're working. And then they have to decide how are they going to determine impairment. And for that, they should come to actually us or someone like us who can present them with a checklist of 8 or 9 categories to check at the job to determine whether or not they're impaired. If the decision by the HR person is you are because of this checklist, then I think we've got very good evidence that will sustain the job action if there's a lawsuit brought.
Okay, so Max, now that we have recreational marijuana in Ohio, we've had medical now for quite some time. One of the issues that comes up is the Americans with Disabilities Act and the Ohio law equivalent. Can you comment how medical and recreational marijuana fits into that statute and what employers should consider?
An easy answer is that it doesn't really, because the Americans with Disabilities Act is a federal law, and obviously there's also an Ohio Disabilities Act, but Ohio law and federal law specifically carve marijuana out. There is no accommodation for the use of marijuana under the Americans with Disabilities Act or Ohio Disabilities Law.
Is there any instance in which an employer should consider maybe if an employee is addicted or something of that nature? How does that work?
I would say that is a narrow circumstance that could arise, and if somebody's addicted, then that is arguably a disability, and it's a disability that the employer has to look at accommodating.
Sure.
It doesn't have to. It certainly doesn't mean that the individual can use marijuana and then come to work,
right.
But it does mean that the employer may need to accommodate recovery from marijuana addiction. Yeah, sure.
Something like that.
Yeah, you got to go to meetings, whatever it might be.
Okay,
Yeah.
perfect. So, Bo, as the executive director of the Salvation Army's Harbor Light facility, what are some of the biggest challenges that you face as an employer dealing with drugs and alcohol in the workplace?
So there's lots of challenges we face, but if I were to say the biggest challenge we face is assisting those that we serve. And depending upon the program that an individual is in, it depends upon the grace that we're allowed to show them when it comes to usage of substances and things like that. And no matter what, we want to show grace, but there are certain areas, different areas where we have to be a little bit more hard-lined.
So is there a little bit of tension? I know that the Salvation Army is a drug-free workplace, but I also know that the Salvation Army is all about compassion and second chances. So do you feel that tension as an employer?
I would say that yes, because especially with our employees, many of our employees are people that we once served.
Right.
And so we also have to realize that when you're talking about recovery, sometimes that's a process.
Right, that's understandable.
And if it's a process, you have to show grace. And but we also can't look beyond certain things as well. And so that grace is, you have to be careful about how we approach that.
It's a little bit of a balancing act, I think.
Absolutely.
Perfect, thanks. So Ed, I know that there's no objective breathalyzer test to determine if somebody is high on marijuana. So when you're doing a field sobriety test, how would you determine if someone is high or not?
So the standardized field sobriety tests, which is the 3 basic tests that a police officer would do on the side of the road, they're not just a pass or fail, they're a totality of the circumstances. So it's based on what the officer sees, what they smell, and what they hear. As a DRE, not only do we utilize those 3 tests, we have a 12-step process that we use to evaluate somebody who may be impaired. Through that process, we can accurately identify which one of the 7 drug categories that person may be impaired by. That is then backed up through a urine toxicology report. And Ohio is actually looking at utilizing oral fluids, basically saliva, we're expecting that to be in the near future, and it'll be just as accurate as a urine toxicology.
So the mouth fluid test would essentially be a breathalyzer for other types of drugs, marijuana specifically? Or?
Yes, but it would not be an instant read. It would have to still be sent to a lab, but it would be just as accurate, and it's in the final proofing phases right now.
So it sounds like if we're talking about kind of best practices for employers, if they're trying to determine if their employee is in fact impaired on the job, is to have a really specific checklist as to what they're seeing, what they're hearing, and what they're smelling, and go through all of those items to determine impairment.
Yes, to start down that road.
Perfect, thanks Ed.
You're welcome.
Okay, Stacey, so as a workers' compensation attorney, what are some policies that an employer can implement to help defend against a workers' compensation claim, specifically with regard to any suspicious drug activity?
Well, I would definitely implement reporting. That's the most important, even above and beyond the drug conversation. You have to have a uniform method of reporting, and usually we recommend that you have an accident report for the employee to fill out, as well as a supervisor report, so you really get both sides of the story right from the beginning. And if you have a reporting policy in place, then there are rules for your employees to follow. And most important for employer defense, which is what I do, we want to know the story right from the beginning. And if you have a policy in place, employees are more likely to fill out the incident report, go for the post-accident drug test, and really communicating with you what happened, whereas sometimes several months can go by before someone reports it, and then the employer is behind the 8 ball because they're not there from the beginning, investigating from the beginning, having a drug test from the beginning, getting witness statements from the beginning, right? So the biggest policies are the reporting to HR that it occurred, and that's why it's important to have it in your employee handbook. I know that you do that.
Yeah.
So the biggest thing that you can do is get an employee handbook, set up a procedure so there's a uniform investigation right from the start.
That makes a lot of sense. So is it fair to say that when workers' compensation, the Bureau is taking a look at these claims, any real-time reporting of incidents, that's going to have a lot of credibility for them because it's actually in the moment. Is that fair to say?
Yes. And as a defense attorney, it helps me see if an employee is not telling the truth, being inconsistent. So it's beneficial to the employee because they're putting it out there that it occurred. But then I can come through that statement later to see if what they're saying is really true.
Perfect. Thanks, Stacey.
Thank you.
Awesome. Thank you. Here, Craig, as the Human Resources Director at Discount Drug Mart, have you guys changed the policies at all in the last few years with regard to drug testing to maintain staffing levels?
We have. We've had no choice, Maddie. And the answer is that a couple years ago, Drug Mart was doing drug testing for every single position, whether you were a stock employee all the way up to corporate office positions. Not only with COVID, but with just legislation in general and exactly what we're talking about today. We've had no choice but to scale that back. So now we have shaved off certain positions that we are no longer drug testing for.
Okay, yeah, it's a little bit of a balance.
It is.